As lawyers, we tend to focus so much on risk, but actually there is real opportunity. And perhaps if you are better able to satisfy a customer that you have robust ESG procedures in place, that may well put you in a better position to win bids, for example, and to develop long-term relationships with your customers.
Welcome to Sustainability Leaders. I'm Michael Torrance, Chief Sustainability Officer at BMO. On this show, we will talk with leading sustainability practitioners from the corporate, investor, academic, and NGO communities to explore how this rapidly evolving field of sustainability is impacting global investment, business practices, and our world.
The views expressed here are those of the participants and not those of Bank of Montreal, its affiliates, or subsidiaries.
My guest today is Stuart Neely, partner with Norton Rose Fulbright in London. Stuart co-leads the global business and human rights practice for the firm and provides counsel on the development of human rights and ESG due diligence programs, public disclosures, transaction due diligence, and grievance processes. Today, we'll be discussing how regulations are driving developments with sustainability and human rights, the role of multinational standard setting, and important litigation trends to monitor. Thank you for joining the podcast today, Stuart.
Thank you, Michael. It's a real pleasure to be with you.
So, Stuart, can you start off by telling our audience more about yourself and your journey to be a lawyer specializing in human rights and sustainability? How did this end up being such a big focus for you?
Thank you, Michael. Nice question to begin with. I guess the first thing to tell the audience would be that you and I have known each other for a very long time because you were previously a senior lawyer at Norton Rose, and we obviously worked in a past life on sustainability and human rights issues. And I think that would go back to 2013 and possibly before. But it was really part of that core group working on sustainability issues back then that we realized clients needed proactive advice on issues like human rights due diligence and other areas of sustainability risk. What led me personally to that and our collaboration together was the fact that before I joined the firm, I did a master's at University in London looking at business and human rights and sustainability law. And I think back then, most of the students would either do commercial law topics like comparative mergers and acquisitions and international law or foreign investment. And then you'd have the other cohort of students who'd focus on topics like human rights and civil liberties. And I think I was probably one of the only ones looking at both. And that's what really led me to this area. So if I hadn't done that, I don't really know what I'd specialize in because I may not have found this area. We may not have had the opportunity to work together before you became partner, obviously, at Norton Rose in Canada and then moved on to Bank of Montreal.
So, Stuart, in the EU and UK, there is more regulation that's focused on setting the ground rules for sustainability and human rights. Can you tell us more about what are the key areas of regulatory activity and the main drivers for legal compliance in respect of sustainability and human rights in the EU and UK?
The way to sum it up would be it's a really complex legislative picture, and you really have lots of overlapping laws which require different things, both at the national level, but also the EU level, which then requires EU member states to either transpose EU law requirements if they're in the form of a directive into their own national legislation, or to give effect to regulations which have direct effect from the EU level down into legislation in individual states. The way I like to try and simplify things for clients is really categorize these types of laws into three buckets. So on the first bucket, you have pure reporting laws. And a good example of that would be, for example, the UK Modern Slavery Act. And these sorts of laws very much focus on transparency. So it's all about disclosure, an annual requirement on companies to publish the policies, procedures, and measures they have in place to address the risk of modern slavery occurring in their businesses and supply chains. In general, those sorts of laws, which really in the case of the Modern Slavery Act dates back to 2015, were considered rather innovative at the time. They're now facing some pressure, or certainly the UK government is under pressure to strengthen those requirements, and it is reviewing the UK Modern Slavery Act as part of its responsible business strategy. And I think that probably applies as a general principle to lots of those pure reporting laws, where we see a pressure to move towards what I would call the second bucket or category of laws, which is mandatory due diligence laws. The particular piece of legislation in this area which has attracted the most attention is the EU Corporate Sustainability Due Diligence Directive, which is rather a mouthful, so people tend to shorten it to either CS3D or CS triple D. And that would require companies which are in scope to conduct mandatory human rights and environmental due diligence extending to their businesses and their supply chains. We might come on to talk about how that legislation is currently in flux as we move through these different types of laws. Another example of this sort of mandatory due diligence law would be the Norway Transparency Act. And what that does is require in-scope companies to conduct human rights due diligence, reflecting the expectations of an international soft law instrument called the OECD Guidelines for Multinational Enterprises on Responsible Business Conduct. And so that takes a slightly different approach to CS3D, the EU directive I mentioned. One, the EU directive is really prescriptive in terms of setting out what companies need to do to identify and address human rights and environmental issues in their businesses and supply chains. And the other one is more reliant on an international soft law framework, which effectively then just enshrines in domestic hard law. So that's our second bucket, mandatory due diligence laws. Within the category of straight reporting laws and mandatory due diligence laws, you have a hybrid type law, which in effect requires companies to do some form of due diligence in order to report. And a good example of that would be the EU Corporate Sustainability Reporting Directive, or CSRD. And as distinct from a pure reporting law, this would require companies to, for example, conduct what's called a double materiality assessment, where they, as part of identifying what they need to report on, conduct an assessment of not just how ESG issues may be material from a financial perspective and the corporate perspective, but also material in terms of potential impacts of the company's operations on people and the planet. And the last bucket of legislation, the third bucket that I tend to summarize is import bans. And often these are focused on a particular issue. So the most notable example is forced labor. So the US had very active enforcement of legislation which prohibits from entry into the United States products which are suspected of being tainted by forced labor in the supply chain. The EU is following suit with the introduction of the forced labor regulation in 2027. And what that will do is empower EU customs authorities to deny goods entry into the EU if there's a suspicion of forced labor. Again, those sorts of import ban type laws in effect imply, and indeed the guidance requires, due diligence insofar as to avoid an inference that your goods are tainted by forced labor, or to discharge an inference where a customs authorities determines on a preliminary basis that the goods may be tainted by forced labor. The way that the company then discharges that presumption is by demonstrating that it has due diligence procedures in place. So there's overlaps between those different laws, but that's generally, Michael, how I try to summarize them for clients.
Well, that's a really good overview, Stuart. In terms of the evolution you alluded to, there's some changes happening in the EU. What's the general trajectory of these regulations?
Yes, there have been some very significant changes. Most notably, the EU Council adopted the Omnibus Directive, which was proposed by the European Commission back in February 2025. Without getting into too much detail about the legislative process, the main outcome is that the Omnibus Directive will now be included in the EU Official Journal, formally amending the EU Corporate Sustainability Reporting Directive and the EU Corporate Sustainability Due Diligence Directive, better known as CSRD and CS3D. And those are the two directives which really formed the backbone of the EU's sustainability framework. The Omnibus Directive, which is the new one passed, amending those directives, amends CSRD by removing about 80% of companies from the scope of it. And that's important not just for EU domiciled businesses, but also companies from outside the EU who are caught or will be caught by CSRD because they have an overall turnover in the EU of 450 million euros or more, as well as an EU-based subsidiary or branch with its own turnover of at least 200 million euros. Now, those changes will apply to companies' financial years starting from January 2027, so not that far away. And in terms of the other key directive, which is the Due Diligence Directive, CS3D, the Omnibus has made some important changes. Significantly, it's increased the thresholds for in-scope companies. So EU companies will only be in scope if they've got 5,000 employees and a turnover of 1.5 billion euros or more. And non-EU companies may be in scope if they have a turnover in the EU of 1.5 billion euros. So that's significantly higher than the previous thresholds. In a nutshell, this directive, CS3D, requires companies to identify and assess actual or potential human rights and environmental impacts, adopting a risk-based approach. This involves a scoping exercise of the company's own operations and value chain before then carrying out an in-depth assessment of the impacts identified as being most severe or most likely. And having done that, the company then needs to implement what's called appropriate measures. So measures which are subject to a reasonableness standard to address the impacts which is identified, including through contracting processes and engaging with suppliers. Now, that directive, CS3D, won't apply to companies until July 2029. But for many companies, this change in terms of due diligence requirements will require a lot of preparatory work in the meantime.
You mentioned international standards, and that's a really interesting area to me. And there's an interplay between these standards and regulatory requirements. Can you talk about the role that standards like the UN Guiding Principles, the OECD guidelines for multinationals, and other standards are playing in terms of setting the expectations for companies and how they relate to regulation?
Yes, of course. It's really important to understand that these international soft law frameworks, which you're talking about there, Michael, which you and I have discussed for well over a decade, really do form the blueprint for some of this new hard law which is emerging. So for those in the audience that aren't familiar with what these international soft law instruments are, the two most important ones to note are the UN Guiding Principles on Business and Human Rights and the OECD Guidelines for Multinational Enterprises on Responsible Business Conduct. In general, what they do is set out the responsibilities of companies in terms of managing their human rights and environmental impacts and setting aside the nuanced differences between them. They are intended to be aligned. Indeed, the OECD guidelines were updated to reflect the UN Guiding Principles. And the core tenet is that companies, in order to meet a responsibility to respect human rights, are required under these two frameworks to identify their actual potential human rights impacts and then take steps to manage those impacts and then perform ongoing monitoring of the effectiveness of those steps and then report publicly on the steps they're taking. So really quite derivative of general compliance risk management principles, albeit the focus is on the risk of the human rights or environmental impact occurring and addressing that impact. But other than that, it really draws heavily from compliance risk principles. As I say, these two instruments really do form the blueprint for a lot of the legislation. I mentioned earlier the Norwegian Transparency Act, which expressly takes the OECD guidelines and then requires companies to conduct due diligence against the OECD guidelines. So in effect, a company which is in the scope of that law is unable to meet the requirements of the Norwegian Act without opening the OECD guidelines to review what they require and then implement those requirements into their operations. In other cases, legislation like the EU Corporate Sustainability Due Diligence Directive I was talking about take a slightly different approach in the sense that Articles 8 to 11 of that directive are quite prescriptive in terms of how companies should go about identifying and then addressing human rights impacts. But it's clear, not just from the recitals of the directive, but also the language used in the operative provisions, that it is informed by the expectations of the OECD guidelines and the UN Guiding Principles. And you can see that really across the piece, all of the legislation, which is emerging globally, to some degree or another, leverages these two international soft law instruments.
Stuart, if you're advising companies, let's say you're talking to a chief sustainability officer of one of your client companies, and they're working in many different jurisdictions. I mean, you outline all these different rules, all these different regulations, all these standards. It's a pretty confusing environment. How do you approach advising them on developing a really comprehensive programmatic way of managing these types of issues? How do you help them to identify and assess areas of risk or think about this in terms of a corporate management program?
Yes, sure. It's the perennial issue. And I'd say the challenge you're alluding to there is how do companies grapple with the piecemeal nature of these laws, noting that many of them are extraterritorial, as I said, which means you may be in a position where you are caught by a reporting requirement in relation to an ESG issue in a particular jurisdiction, and you haven't even identified that. Now and again, we are approached by clients who've identified that they were caught by a particular reporting requirement, say the Australian Modern Slavery Act, and didn't realize that. And they had been caught by the Australian Modern Slavery Act for the last 3 years. So they then have to effectively backfill the program and then start reporting and regularize the position with the regulator in that particular jurisdiction. So in terms of how we support clients, I think one of the first things to do in terms of grappling with this piecemeal legislative picture is to do a scanning exercise to essentially identify which of these laws may apply to the business. And then you approach the issue of, well, they are overlapping and diverging at the same time. So part of the role of both internal legal and compliance, working with other functions, but also external counsel, is to advise clients on how they can develop a group-wide program which builds on, in particular, the international soft law instruments we were talking about there, and is able to be flexible enough to take into account technical law compliance of these different laws. So effectively, you are building a program which, on a risk-based approach, applies a consistent approach to due diligence and reporting, but then also makes sure that it meets technical local law compliance requirements. And I think part of the role of external counsel is helping clients to understand the nuanced differences between some of these laws so that they can embed those requirements within the program so that they can manage risks. I think the other key role for lawyers in guiding clients is to support them as they engage with technology providers, which help them to gather and digest significant amounts of sustainability data. I mean, Michael, you'll know this better than most, or anyone really, but the importance of gathering data from suppliers and satellite mapping data, sector risk data, geographical risk data, AI generated data, all of which sits outside the responsibility of external counsel, but where external counsel needs to be able to support clients to know that they are doing enough and also provide them with the level of comfort they need so that as they're gathering all of that data and then reporting on it through the external reporting channels, that will be sufficient to meet legal compliance. And I think that understanding the different roles that legal counsel plays working with other functions and other service providers is really important.
And Stuart, there was a time before a lot of this regulation was out that one of the main drivers of company activity around sustainability and climate or human rights was actually customer or investor interest and demand for more robust programs around human rights and sustainability. Is that still the case? And what would you say the current state of play is in terms of those non-regulatory drivers for this work?
I completely agree. I think those points remain valid to this day, and probably much more. I think on the customer side, I love the adage that everyone is effectively in everyone else's supply chain. And I think that's relevant because we've explored on this podcast so far the due diligence and reporting laws that directly impact in-scope companies. They have a much greater consequential impact indirectly on out-of-scope companies who are in the supply chains of in-scope entities. And so we frequently are called upon to support clients who may not necessarily be caught by, for example, the due diligence directive, but where their customers are now demanding of them that they implement certain human rights and environmental due diligence procedures. So I think that customer imperative remains ever present. On the investor side, as you'll be aware, investors are increasingly using sustainability screening as part of their investment decision-making. And even where investment managers don't specifically have an express sustainability mandate, human rights and other ESG type scandals can have financial implications. And I think one of the most interesting things that we've seen here in the UK is just last year, we saw our first ever claim brought against a company by investors. And that claim followed a scandal concerning alleged labor welfare issues in the company's factories. And that led to a drop in the company's share price when that story hit the press. And so we think that will be a trend where investors seek to bring claims against companies and not just necessarily through effectively claiming for direct loss as a result of the company's share price falling, but also potentially, for example, derivative claims against directors personally on the basis that they failed to manage these ESG issues properly, and by doing so failed to comply with their directors' duties and the duties to act particularly in the best interest of the company or to act with reasonable care, skill and diligence. The reality is those claims are very difficult to bring, but frequently they aren't brought on sound legal grounds. They're brought specifically to draw attention to an issue, and it's that reputational risk that companies also face.
Stuart, oftentimes these topics are discussed in terms of risk. What are you seeing and how do you think about this as a possible opportunity for a business? That can be a little easier in the context of climate change, for example, where there's a lot of investment happening in the space. In human rights, it might be a little bit more challenging, but what are your thoughts on these topics as opportunities and not just about risk management?
I completely agree, Michael. And this is one of my favorite topics because, as you say, as lawyers, we tend to focus so much on risk, but actually there is real opportunity. And perhaps the point I made in answer to your previous question about customers and the imperative there is demonstrative of that, in the sense that if you are better able to satisfy a customer that you have robust ESG procedures in place, that may well put you in a better position to win bids, for example, and to develop long-term relationships with your customers. So that really, I think, reflects that general recognition that strong performance in this area will help companies in terms of winning contracts, but also meeting counterparty due diligence criteria, also higher ESG ratings, which can make securing finance easier. There are also lots of studies that show that supply chains are more resilient from a business perspective if there's strong collaboration between customers and suppliers on ESG issues. In a sense, you've got both the customer and the supplier there investing in a long-term relationship. So I think that, in answer to your question, Michael, is another example of business advantage rather than focusing on risk, which is often the case in this area.
And I know one of your areas of focus, Stuart, is around disputes and litigation, and you keep a close eye on trends in that area. What can you tell us about litigation? What are some of the notable cases you've seen over the last while? Any trends for us to pay attention to?
If I were to focus on what's been happening this side of the Atlantic, the UK, Germany, and the Netherlands in particular, I would say, have seen lots of claims brought against companies for alleged breach of duty of care for a range of ESG impacts. I know that's also something which you've seen over the years in Canada. But it's interesting to see how those sorts of claims evolve, because what they do is they leverage relatively old law in the form of traditional tort principles and the law of negligence within that to allege that companies ought to be liable for human rights and environmental impacts in their value chains. And so it brings that new novel ESG or sustainability lens to fairly old legal concepts. So initially, this sort of case law developed, certainly in the UK, around the idea that parent companies could be held responsible for impacts of subsidiaries abroad. That's evolved now. So we've seen a number of cases in the UK courts focused on allegations that companies ought to be liable on the basis of a breach of a duty of care for human rights issues in the supply chain, where suppliers are alleged not to have complied with specific forced labor conventions, for example. What we also now see is claims against companies for their alleged contribution. Initially, those sorts of claims focused on the idea, certainly in the English courts, that parent companies ought to be responsible for the impacts or alleged impacts of subsidiaries abroad. We've seen that emerge now in a number of cases against companies for alleged human rights impacts on the supply chain. And this year in particular, what we now see is claims against companies for their alleged contribution to climate change, which claimants say increased the scale and probability of natural disasters. Now, as the courts have emphasized a number of times, these sorts of legal arguments, effectively in the English courts based in negligence, are at the periphery of where a duty of care may be found to exist. And indeed, a number of these cases, when tested on the substance and trial, will no doubt fail. But the emphasis is clearly that this jurisprudence is evolving because activists and NGOs and claimants are looking to establish the circumstances where companies may be responsible for those sorts of issues. And in other jurisdictions like Germany and the Netherlands, we see similar cases. So, for example, this year in the German courts, a case was brought against an energy company by a Peruvian farmer who alleged that he ought to be compensated for the cost of future-proofing his property from the risk of melting glaciers and flooding. Court decided that although in that particular case, the farmer, for the purposes of the German civil code, hadn't established the immediate risk to his property, the court very clearly left open and indeed affirmed the concept that that duty of care could exist in another case. And so we see this case law emerging, and it's really leveraging those existing tort principles. So I previously mentioned the EU Corporate Sustainability Due Diligence Directive and how one of the key sticking points in those negotiations in the EU Parliament at the moment are about whether or not the provisions around civil liability should remain. What's clear is even if that provision isn't retained, the national law of many jurisdictions still provides for routes to potential liability for companies. And then, as previously mentioned, we've also got investor-related claims, which are clearly on the increase, either in the form of derivative actions against directors or straight claims by investors for alleged loss of share value as a result of ESG scandals.
So, Stuart, the U.S. regulation in this area is often through trade law. How are you seeing the evolution of U.S. trade laws incorporation of human rights? And with all of the political changes that we've seen, is there any trends in terms of that going away or becoming more pronounced?
It's a great question. One sustainability issue which has long since been on the US political agenda and doesn't seem to show any signs of changing is forced labor. And your point there, Michael, about trade law is important because one of the key tools that the US has in relation to that policy is the implementation of these forced labor import bans, which I mentioned under the US Tariff Act, which is a long-standing piece of legislation dating back to 1930, but which has seen in recent years increased enforcement after the removal of a loophole, which effectively meant that US customs could actively impose what's called withhold release orders on goods which are suspected of being tainted by forced labor. And then the Tariff Act supplemented by, more recently, the Uyghur Forced Labor Prevention Act, which is a very similar piece of legislation, which entitles US customs to presume that goods partly originating from the Xinjiang region of China are tainted by forced labor unless the importer can demonstrate otherwise. And the way in which the US government's guidance worked is effectively a company can only demonstrate that its products are not tainted by forced labor where that presumption is imposed if it can demonstrate it has appropriate forced labor due diligence procedures in place. So that seems to be an issue which there's political consensus between the EU and the US, with the EU now, as I mentioned, introducing the forced labor regulation from 2027, which will impose similar forced labor import bans, and other jurisdictions like the UK notably considering this too. This is likely an example of a sustainability issue where there will be increasing consensus in jurisdictions, which then will determine how companies take this issue into account when structuring their supply chains.
Stuart, final question. What would you suggest to, again, people who are leading this type of function within a company in terms of being proactive in their business to manage these risks, getting ahead of these trends? There's obviously a lot of complexity. There's a very fast rate of change. If they are to be proactive and leaders in this space, what would you recommend they do?
Yeah, it's a really good question and helpful way, I think, to conclude. The starting point would be to proactively check if any of the existing due diligence reporting laws, which I've mentioned, apply to the business, noting that many of them are extraterritorial in nature. So, for example, the UK Modern Slavery Act extends to companies carrying on a part of their business in the UK, even if they are not themselves UK companies. And it's a fairly similar test under the Australian Modern Slavery Act, for example. And as I mentioned, both the EU Reporting Directive CSRD and the Due Diligence Directive CS3D may apply to sizable non-EU companies if they meet the relevant criteria. So that's an initial step where companies can first identify the legal requirements that may apply to them and then determine how they respond. That should also extend to laws not yet in force but coming down the line, such as the EU Deforestation Regulation, which after some back and forth is now scheduled to enter into force in December 2026, the EU Forced Labor Regulation, which is coming into force in 2027, and CS3D, which is 2029. Having done that, the next step would probably be to look at the company's governance, by which I mean assessing where responsibility for the sustainability program sits within the organization, and also which management or board subcommittees have oversight of that. And that'll give you a good platform for reviewing the company's due diligence program to ensure it's fit for purpose in terms of its policies, procedures, and risk assessments in place in response to the laws which we've been talking about. It's also important to recognize the commercial opportunities which come about here as customers and investors begin to ask questions in these areas as part of their own due diligence. Having a robust sustainability program is a competitive advantage.
That's great. Thank you so much for your time today, Stuart.
Thank you, Michael. It's a pleasure speaking with you as always.
Thanks for listening to Sustainability Leaders. This podcast is presented by BMO. You can find our show on Apple Podcasts, Spotify, or your favorite podcast player. Press the follow button if you want to get notified when new episodes are published. We value your input, so please leave a rating, review, and any feedback that you might have, or visit us at bmo.com/sustainability leaders. Our show and resources are produced with support from BMO's marketing team and Puddle Creative. Until next time, thanks for listening and have a great week.
For BMO disclosures, please visit bmocm.com/podcast/disclaimer.